Hi, I am Monica Miller. I am the legal director and senior counsel for the American Humanist Association. My pronouns are her, she, and I am on land occupied by the Miwok people. I am very pleased to introduce and have a discussion today with Rachel Laser, who is the president and CEO of Americans United for Separation of Church and State. And she's also a lawyer, an advocate, and a strategist who has dedicated her career to making the country more inclusive. So welcome, Rachel.
Hello, I'm unmuted. Thank you so much, Monica, and hello, everybody. It's an honor to be here with you today. I am Rachel Laser. I'm the president and CEO of Americans United for Separation of Church and State. I use the pronouns she and her, and I am on the occupied land of Piscataway, Kahnaway, and Nacotchtank people. So Monica, I'm looking forward to chatting with you about what was an unfortunate Supreme Court term.
Correct. It was unfortunate indeed. I was actually just going to ask you, we had a handful of rulings this summer, a number of them impacting church-state relations. I think we would probably both agree that the Espinoza versus Montana Department of Revenue case was probably the case that had the most impact on church-state relations. Would you agree that's the case? And then if so, kind of maybe tell us a little bit why that is.
So let me just start by saying it's a tough one. There were an unfortunate number of cases this term that took up religious freedom. As soon as the Title VII cases came down, which we celebrated, when we saw, it was sort of incredible. Justice Gorsuch wrote the opinion. All of a sudden, it was clarified that there couldn't be LGBTQ discrimination in the workplace and that was part of Title VII of the 1964 Civil Rights Act. And then there was this one paragraph at the end of the opinion that said, and by the way, there's this super statute, the Religious Freedom Restoration Act, and that may open the door and open the floodgates to a huge gaping hole in the middle of this newly clarified right. And that sort of signaled, we've got 3 cases coming that are directly on religious freedom and we may be in trouble. The Espinoza case is particularly a bad one, and I would say it is for 3 reasons. The first reason is it overruled decades of precedent, and it declared that taxpayers can be forced to fund religious education where the state has a voucher program. That's a really big deal, right? Like the 2002, the Supreme Court went with this fiction that, vouchers weren't sort of direct government money. And so said that, they were possible and it wasn't necessarily a violation. What's new about this is the required part.
Right.
Now your and my taxpayer dollars are required to go to support religious schools if, the state has a voucher program. That's reason number 1. Reason number 2 is it advanced this other fiction and this argument that we're hearing a lot right now from religious extremists, that it's somehow discrimination against religious institutions if they get special treatment when it comes to getting out of government burdens, so they don't have to comply with anti-discrimination laws, but if they don't get equal treatment when it comes to government benefits, like funding in this case. So somehow, we're living in this new world where, religion is treated different in a lot of ways by our government and given special benefits, but now religious institutions get to have it both ways in order to be equal. That's reason number 2. Reason number 3 is that we've been fighting hard this redefinition of religious freedom that shifts it from what it was intended to be, which is a shield to protect us all, right? To be religious, not be religious, change our belief system along the course of our lifetime, as a shield for us, and it changes it into really a sword and weaponizes religious freedom and allows it to be used to license harm to others. And in this case, the reason I say that is because we're talking about forcing your and my tax dollars to fund religious schools that can get around all of these civil rights requirements that apply to, for example, public schools. So, religious schools can turn families away because they don't share their religion. There's a track record of them turning families away because they're LGBTQ, or students away because they have disabilities, or teachers away because they get in vitro fertilization. And I'm not saying all religious schools, but too many. And therefore, what we're talking about is this notion of religious freedom being used to allow harm to others. And that's very dangerous. And we're seeing so much of that today.
Absolutely. And I think when you combine the Espinoza ruling with the other rulings involving, the ministerial exception, where you have two, Catholic school teachers who teach, the range of subjects that you would in, say, in elementary school, art and math and so forth, and you just wiped away those protections for those religious teachers. We're not talking about atheists. We're talking about, bona fide, maybe Christians or Catholics. And sometimes these schools employ people who aren't. And that actually is kind of one of the points of those rulings. But we saw in a few weeks' time, expansive, broadening of treating religion differently and giving them exemptions, and at the same time saying that they must be treated as equals when it comes to, getting government funds. So they, like, you said, they're getting their cake and eating it too. They're getting the exemptions, they're getting the special treatment when they want the special treatment, and then they're getting, off the hook when they want to get off the hook. And that creates definitely a problem. I think there was another, you mentioned three significant reasons why, the Espinoza case, what marks maybe the most significant church-state separation case of the summer. I would say maybe a fourth one is, and maybe it's related to your first point about calling into question and overruling decades of precedent, and frankly flipping church-state separation on its head. But we have the issue of those no-aid clauses, sometimes pejoratively referred to as Blaine amendments. I believe 37 states have those. The Supreme Court went a little out of its way in the Espinoza case, the majority did, of course, to call into question no-aid clauses that are in state constitutions. Do you kind of want to talk a little bit about that, like where you see the state constitutional provisions that protect church state separation, but in a very specific way, where they say you can't provide aid, to public schools, to churches, very directly?
Yeah, absolutely. Right. So, 37 states have these no-aid clauses in their state constitutions, and they're really, seen as going further and protecting, the separation of church and state than the Establishment Clause has been interpreted as doing, so far. So they're really important. They apply to houses of worship. They apply to often to religious education, and they've been a really important way so far to fight school voucher programs, which primarily fund religious education. So they are very important. And you're right that what we saw in the Espinoza, concurrences is that we've got some Supreme Court justices that are out to, try to declare unconstitutional these no-aid clauses. Right. That did not happen here. So that's the first point that I want to make, that fortunately the no-aid clause, this is sort of technical and lawyerly sounding, but the no-aid clause wasn't what was at issue in this case. It was the application of it. And so, we didn't have to worry that this case actually established valid precedent specifically on that point of whether a no-aid clause is unconstitutional. It did not. So on the one hand, there's no question that these no-aid clauses are in the crosshairs, and that there's a very well-funded movement to go after them right now, and that we're going to see sort of stepped up legal action against them, but on the other hand, there's good news, right? So starting with the fact that, the case didn't make any declaration as such that the no-aid clauses are unconstitutional. And secondly, that, these no-aid clauses really differ across the state. So for example, some of the no-aid clauses say that you can't fund any private education whatsoever. Right. And those are still valid for sure after Espinoza. There's no question, because the Espinoza case just said, if you're funding as a state private schools, then you also can't exclude the category of private religious schools. So that, so like those would still be allowed to stand. There are other no-aid clauses that go specifically to religious uses. right? And this decision, right, Justice Roberts,
Yeah.
who wrote it, went out of his way, and it's, to me, there's something incredibly fictional about it, but nonetheless, we're going with it because
Yeah.
it's a significant distinction that he went out of his way to say, like the Trinity Lutheran case, which is the playground resurfacing case, that all that we're talking about here is that you can't exclude religious institutions based on their religious identities.
Right.
And it didn't go, according to the Chief Justice who wrote the majority opinion, to religious uses. So that where you have no aid clauses that do specifically go there, this case didn't rule on that. So we're, there's some hope left.
Correct. And I would totally agree with that, both with respect to the not actually overruling the no aid clauses. And I'm glad that that's your take as well. I mean, it's certainly it's almost like the lemon test. I mean, it's getting called into question by the court. I mean, the majority is bending over backwards to force that into play when it really wasn't at play at all. But definitely, even the Montana one is still there on its face. It's just that, like you said, when it's interpreted to mean a certain thing. Now, I do think it's really interesting that the use wasn't part of the analysis, because on the one hand, we have the benefit of them not putting that into play and trying to make sense of the distinction between what type of aid we're talking about. Because as you mentioned, Trinity Lutheran, we're talking about providing a secular gift, if you will. It's tan bark or was used tires to resurface kids' playgrounds. Now we're talking about teachers' salaries. We're talking about ministers and houses of worship. I mean, it's probably not going to be limited to vouchers here. The analysis in the ruling, when it came down to it, I mean, the takeaway feels like this automatic thing. Ultimately, the court still has a test involved, and I think it was a version of strict scrutiny. So it's not to say that automatically all these programs are going to be allowed. There's still an analysis. But it felt, as you sort of alluded to, very superficial and without substance. So it is a little bit hard to understand where that use distinction will come into play. I'm curious what you think of, how we might see this ruling go beyond vouchers and what we should look out for. Is it going to expand to, these federal loans that are being given to churches right now for the coronavirus relief that they might forgive, and now we're giving direct federal taxpayer dollars to churches? Do you think that the Espinoza ruling will kind of come into play with that stuff?
Yeah, no, that's a great question, and it's a real concern. Look, the Espinoza decision was terrible, but it didn't go to all of the worst places. And let me just explain. So and then I'm going to answer your question, about how far it goes. So for example, it didn't say, as we just discussed, that a state is prohibited from a restriction on funding religious activity, or content, right? It just said you can't exclude a religious institution based on its religious identity, right? What it also didn't address was whether or not you can preclude state funding for discrimination that violates state, and federal anti-discrimination laws. It didn't reach that. And just as an example, 10 of the 12 religious schools in Montana, which is, where the Espinoza case took place, that applied for this tuition credit money from the state, had discriminatory policies on their books, right? And the court just didn't even address that, right? And that's significant. Furthermore, the court, this was a decision that was contained to the area of vouchers, right? So it wasn't a decision that was about direct aid, right? And direct government subsidies. And that's really significant too, right? And fourth, as we talked about, the decision didn't say, from here going forward, taxpayers all across all 50 states are definitely funding religious education in every state. It just said, if you have a voucher program, then that voucher program cannot exclude religious schools based on their religious identity, right? But let me go back to the third one, right? Because it's significant. The fact that the decision didn't reach direct government funding and subsidies. So let's talk about that payroll protection money that you just raised. That is as direct as it gets. That is money that is directly being transferred from the government, from all the money that you and I and all of you pay out of every one of our paychecks. And it's going directly to houses of worship to fund clergy salaries. And it's also going to religious schools, right, without any restrictions on how they can use the money. And actually, Americans United just did a report on that you can find on our website. We scrutinized, right? There were FOIA requests, there were records released of everyone who got over $150,000, every religious institution, and we scoured those records for religious schools that got the money, and we found that religious schools got up to 6.5 almost $1 billion just from the PPP program. So, there's no question, Monica, in response to your question, there's no question that if there is a lawsuit that's brought challenging this use of PPP money as an establishment clause violation, that you can bet that the Becket Fund and others will be in there saying, but look at Trinity Lutheran, but look at Espinoza, but we have a really strong argument to make that distinguishes direct government funding, in particular because when you think about the origins of the First Amendment and the religion clauses,
it's right there.
Came into being to fight taxation that was directly funding churches, right? That was its origin. Yeah. So it is the greatest corruption that you can sort of imagine, that's taking place. So I hope not. And I'll just say one more thing. And I know that we don't have that much time together, so I apologize for long answers.
Oh, please. Thank you.
I will also say that I could see the same Espinoza, Trinity Lutheran type of argument about, religious discrimination that we talked about when you aren't, treating religious institutions equally, coming up in the context of like historic preservation. So in these cases, which we've won a lot of, where a religious institution, needs to support certain renovations, et cetera, that goes directly to, their religious uses, right? That's about, that's core to their structure, literally. And we've been successful, so far in churches and houses of worship not getting that money. But, you could see the same type of argument being used there, just as another example.
Totally. I mean, that's actually, that's been on my mind, even really since Trinity Lutheran. And frankly, in some ways, I'm a little bit surprised that, in the wake of that decision, we almost didn't see way more states kind of experimenting and going really far into pushing the bounds of Trinity Lutheran. It's not to say we're not seeing it. And I think these federal loans, to churches is unequivocally one of the biggest priorities all of our groups kind of have right now when it comes to this, because like you said, this is why, this is one of the main causes of, what our founding fathers were concerned with when they drafted the First Amendment. It's right there in the legislative history. This isn't one of those, how would they have interpreted a Ten Commandments monument on a park or, prayer in school? I mean, this is right there in sort of the founding documents about where they saw church-state relations. And when it came to a federal government, I mean, it's Congress shall make no law, and we're talking about the federal government. There's just no, I can't see how Justice Thomas is going to write his dissent should we prevail in this lawsuit, because he can't go on his whole spiel about the Establishment Clause not applying to the states. It's right there. It's the government, federal taxpayer dollars direct, very direct funding to religious usage. And that is scary, knowing that it is going to still be an uphill battle for us to prove that. I mean, we have the Becket Fund, we've got Federal Society against us. So it is definitely on our radar too over at AHA. And I imagine that if and when those loans get forgiven with respect to, religious entities, that all of our groups will coordinate and strategize and make sure we come up with the best kind of case for that, because we have, it's a little David and Goliath with respect to who we are up against and what we're up against, as you know.
Indeed. And I think in particular with the with the pandemic happening, that it's a particularly hard moment to be, sort of standing up for our constitutional rights when they're tough and when a lot of houses of worship are suffering, and providing support to their communities. And I know we all really empathize, and that is really tough. But in moments of crisis, that is not a time to abandon our constitutional principles, which frankly, in a time of such division as well in our country, it's our Constitution that is the glue in America. I mean, we don't share, an ancestry or a national origin. What we share in common are these foundational principles of freedom and equality for all. So it's a tough time. And as you say, I mean, I like the David Goliath, I mean, it's
Yeah.
tough. It's tough.
Yeah. Yeah. And I think that this is an area, especially in the wake of the rulings that constrict the rights of religious employees. We're talking, whether it's like a Hobby Lobby type of situation. Now we're talking elementary schools. You can get fired from an elementary Catholic school because you had breast cancer and you needed to take a leave of absence. And we're not just talking, they get some sort of presumption that that's allowed. We're saying you can't even sue them under this ministerial exception ruling. And so I wonder, from your perspective, what role you see kind of bringing in, or how we might be able to bring in religious allies. Maybe they're progressive, maybe they're not. We know we have a lot of relations with the Baptist group. How, as Americans United is not an atheist organization, is there an effort, an increased effort sort of to ally with other religious groups to kind of fight these things, to help them understand how these rulings take away protections from religion too?
Absolutely. So as a start, so my organization, Americans United for Separation of Church and State, is turning 75 years young in 2022. So we've been around for a very long time. And we were actually founded by a sort of politically and theologically diverse crowd, but they were pretty much all people of faith. And what I've seen as sort of so far in my 2.5 years of leading the group is that it's people who have the strongest religious or non-religious identities, both, that are our strongest proponents and our strongest supporters, because they understand how important it is to freedom to be able to have the freedom of conscience and the freedom to believe and be who they are, in this way. And so, the other thing is that there is this sad reality, which will go away when we've achieved true religious freedom in this country, which is that people of faith, and let's be honest, especially Christians, which I'm not, by the way, are presumed to have the greatest moral authority in our nation, and it's sort of, it's one of those things that, as a Jewish girl growing up in the city in Chicago, it's kind of as hard to believe as, how much prejudice and bias there is against atheists and non-theists in this country, and I have members and supporters of Americans United telling me every day stories about my siblings tried to discredit me on the stand from being the executor of my father's estate because I'm a non-believer, or, and so anyway, the point here is that, bringing in faith voices is really important, both because there is still in this country, we are a predominantly religious country, right? We're almost 70% Christian still, not white Christian, by the way. That majority went away in 2014, but we are a majority Christian. We're a majority religious. A lot of people say that's true because we have the separation of church and state, right? Yeah. And so, and also because so many people of faith actually believe so wholeheartedly in this value of religious freedom and are pained by its misuse, try to harm our neighbors and fellow citizens.
Yeah, absolutely. I mean,
we do a lot of that work. Yes.
Yeah, no, I know. I mean, it's fantastic work. And I found us working closer with the Baptist Joint Committee and Holly Hallman, who we did a little Humanist Legal Society event before the Espinoza ruling came down. And the way she put it is like, we're acutely aware of how, you can't take government money without expecting at some point to have strings attached. Now those strings are kind of loosening with these other rulings we're seeing, but nonetheless, I mean, it's getting that voice out there. I mean, they were there on the Supreme Court steps for our Bladensburg Cross case, almost speaking the loudest to say, we don't want the government to tell us what our cross means. This is our quintessential religious symbol. And now you've got the government distorting that meaning to the point where they're saying it's not religious. It represents World War I. There's no religious meaning to this cross. And that's deeply, deeply offensive to many devout Catholics and religious people, of the Christian faith. So I think it's important to kind of, some of these cases just, they flew out, and I've talked to a lot of friends who are politically savvy they're not attorneys, but they're, abreast of all these issues. And I think because of the COVID news, we've got serious issues with race going on in our country right now. These are, it's almost like watching our separation of church and state, our foundation of our country, just kind of like slip away under people's radar. And I think it's really vital we kind of bring that importance to, the masses, and in a way that we're not saying this was overruled, because as attorneys, we still have to be careful of, the sky is falling, but we can still pick it up, kind of thing.
Yeah, and I'm so glad actually that you brought up this moment of sort of reckoning around our inability to achieve our ideals on racial equality in this country, because here's something else that I think not enough of us that are part of this church-state separation or, religion government separation movement, as we all just talked about, have thought enough about, which is the deep roots of the misuse of religious freedom in advancing racism in this country. And I think that, there are incredible allies in the Black and Brown communities of faith and Black and Brown advocacy communities in general around different issues, because this history, just like so much of what white people are oblivious to when it comes to the suffering and oppression of Black and Brown people, because we don't live that reality. Right. So many white people in our space of church-state separation are unaware of that history and unaware of the way. If you want to really read about it, you could read the NAACP's amicus brief in the Masterpiece Cake Shop case, because there they just lay it out, right? The government's repeated misuse of religion and Christianity often to advance racism in the Dred Scott case, citing the Bible, in the lower court in Loving versus Virginia, fighting where the judge was sentencing the couple and said, by the way, like the Bible says that these races should stay separate. And really through to today, even when we saw Attorney General Jeff Sessions arguing that, Corinthians from the Bible justifies keeping primarily brown children in cages, right? And so we just, it's part of our past, it's part of our present, and we would do ourselves better to forge many more allies and make sure that this cause is opening itself up to the breadth of ways that we are fighting racism at the same time as we're fighting its misuse for various other forms of oppression.
100%. And just sort of to wrap it up, because I know we're about out of time, but the voucher program itself, any sort of voucher program, is a way to take money out of the public schools and funnel them into private schools. And those private schools are allowed in many respects, and will probably be even more allowed to with respect to these, broadening of the religious exemptions, but to discriminate. And yes, they're not technically allowed to right now with race and this and that, but it doesn't mean it doesn't happen. It doesn't mean it doesn't go under the radar. It doesn't mean that, these exemptions, with respect to the ministerial exception, won't end up allowing that. And ultimately, it's still taking money away, the public fisc away from public schools to make programs better for lower income people. And absolutely, these church-state relations, and I think both of our organizations, because we're not exclusively, about atheism or fighting against religion as much as we are about protecting church-state separation, it kind of does give us a little bit more room to advocate for those ideas, to kind of educate people about why church-state relations completely impact, women's rights, minorities' rights, and so forth. It's not just about religion.
Exactly. And that's also a key to reaching younger people. And we're not going to protect the separation of religion and government unless we're really reaching those Zoomers, as they call them, Generation Z, like the boomers, and making sure that they value this issue. And the way to do that, like you said, is, do you see its connection to reproductive freedom? Do you see its connection to LGBTQ equality, racial equality, immigration rights, right? Fighting the Muslim ban. So many spaces of overlap where really the separation of religion and government is so foundational, which I know you all appreciate, but we just have got to be louder to communicate that to the next generation of leaders.
Yeah, you're right. And the youth especially, that's a population that they're so activist right now. They're so forceful that it would be, remiss to not try to bring them into our church-state separation or government religion relations fold to help use their voice and channel it in ways that we're not even maybe able to understand.
Exactly.